and would like to welcome everyone to this week's Wednesday webinar. We record these and they're posted there in the blue link, extension.umd.edu/women in ag. You can see the upcoming webinars. We've just announced 2019, as well as archive webinars from previously. We do have a conference save the date, February 13th, 2019 for the conference, Women in Ag. We also have Annie's Project classes that will be happening after the first of the year. As always, a big thanks to the sponsors of the Women in Agriculture programs, as well as our collaborators. So with that, I'm going to go ahead and turn today's webinar over to Paul. He's going to be talking about farm lease agreements, something he's talked about ever since he arrived here in Maryland, a big topic that we have. So thank you for being with us today, Paul.
Thank you for inviting me today. And then, having just done this yesterday, one would think I could remember how to do it.
And share your screen, yep.
I share my PowerPoint.
Perfect.
And hopefully that pops up. And then please let me know if when I go to full screen.
That's right, you're a Mac user.
Yep.
And yeah, we're seeing presenter view.
Oh, okay, so yesterday everybody saw presenter view as well, so that's what I tried to get them to tell me.
There we go, perfect.
So, okay, so that works for me. Okay, so yes, as Shannon mentioned, I'm going to talk about ag leasing today. As I looked back, I hadn't talked about this in about 2 years, so this is a good time probably to talk about it and try it again. And sadly, you know, I have 44 slides. So I'm also a part of the Ag Law Education Initiative. It's a collaboration between the Francis King Carey School of Law at the University of Maryland, Baltimore, College Park, where I'm located at, and the College of Ag and Natural Resources, and then UMES, School of Agricultural and Natural Sciences. We're funded by Empower. We have a link to our website there, Facebook, social media. So if you have questions, you can email us at that email address as well. I'll skip the Empower slide, but we're funded through Empower, which is a collaboration to bring Baltimore and College Park together to work on issues. None of this is legal advice, so hopefully now that it's being recorded, everyone will remember that. And I will skip to the next slide. In my department, we do the Maryland Risk Management Education blog. You can find it at agrisk.umd.edu. You can sign up there, or you can text into that number. And I think I sent these PowerPoint to you, right, Shannon, to post online?
Yeah.
Even though you were muted. Okay, perfect. And if you like the sound of my voice and enjoy listening to me talk, you can listen to me read my blog post to you, and I do that about 2 times a month. Every other week there should be one coming out, so there'll be one next week, and always on Wednesday afternoons around 10 o'clock they come out, and they're on iTunes, Google Play, TuneIn. And today we're going to talk about the ag leasing book that I put together when I first got here. That is where you can find it at, and it should take you to the website to download the book. It is a very large file. I think it's about a 40 to 50 page PDF. It has form leases in it that you can use to kind of guide yourself in your operation. They're fillable. They're also on the grain marketing website, which is extension.umd.edu/grain marketing, if I remember correctly. I don't think I have a link to it in my slides. But you can find those there. There are other videos talking about some of the issues that we're going to talk about today to kind of do more in-depth on them. I'm just going to kind of hit a broad overview today. So to kind of give a little bit of an overview of the topic, 42% of all land in Maryland is in some way rented. Farmland specifically. I looked at Delaware, it's about 53%. If there's anybody in Virginia or Pennsylvania, I forgot to look that up. My apologies for that. But we're dealing with a large percentage of land, and my guess is if I looked at Pennsylvania and Virginia, it would still be a high number, somewhere near 50%. But we're dealing with a large number of land that's rented, and there are a lot of issues that come up when this farmland is rented. The biggest issue that typically comes up is when we're looking at this, we may have No real written lease, and then there may be communication issues that pop up between the landlord and the tenant over the life of the lease. With no written lease, we may have ag leases that started, 20, 30 years ago and have continued on. Parties involved in the lease may have passed away, and it may be really hard to figure out, who is doing what in the lease and what should be going on specifically. In that case, especially when the next generation takes over and memories become faulty over time. Communication can just lead to issues if we're trying to do something with the land and the landlord's not aware, the landlord wants to do something with the land and the tenant's not aware of what's happening. If the landlord's trying to sell, this lack of communication can then lead to disputes as well. So to be a valid lease, as we look at this, we really need to have 4 things. We need to have a valid contract. When we look at leases, they're just a contract. And with that, we can really write these things really any way we want to kind of reflect what we need them to do. When you look at the form leases online, they're kind of generic. They reflect generally what we thought people would want in a lease, but you can go broader than that and kind of be more creative. And I should highlight at the same time, my counterpart, Sarah Everhart, has a book on our website that kind of reflects conservation issues in all of this as well. So if there are conservation issues you want to take into account when you're developing the lease, you can put those on there as well and kind of integrate some of those lease terms into the form leases online. We also need to know the extent of the property lease. If we're looking at this properly, we really do need to know, what's actually being leased and what isn't being leased. We need to know how long the lease is going to run, at least. It may be, I'm going to show some open-ended terms that kind of don't reflect a definite time, but they do, at least in the eyes of the law, reflect something that's slightly definite. And we do need to know how much the rent is going to be in all of these cases. And you notice I didn't talk about it being in writing. It's a good idea to put them in writing, but at the same time, they really don't have to be in writing, as long as it meets these 4 requirements. So what happens when you fail to put it in writing? The failure to put it in writing can lead to some issues, and there might be reasons why we want to have basically an oral lease or verbal lease where it's just spoken and there's nothing in writing really, and we just trust each other with a handshake deal. The pros are it's really simple. If we go back to my list before, it's really just going to be the rent, the lease term. It may have a few other clauses, but it's going to be really light in what's going on in the lease. It does show trust in the other party. We all like to believe that each other and ourselves are reputable and honest, and we're all going to live up to what we kind of say we're going to end up doing. But at the same time, we may not. There may be issues just because we heard one thing, we didn't actually understand what was being conveyed to us. So these issues can pop up and can lead to disputes as we move through some of these leasing issues. At the same time, it may not meet all the legal requirements. We're going to talk about times when leases actually are required in writing under the law. And if it's longer than the period of time that the law allows for just a verbal lease, it may end up being a problem and cause us issues down the road. At the same time, we have no written record of what was said. We just have each other's memories to reflect upon. So if there is a dispute, it becomes a who said what in what situation. And apparently something is picking up on my computer, and I need to figure out what that is. Real quick.
Reduce drift. And
oh, sorry. Apparently I left Pandora open, and it was causing me problems. So now back to the PowerPoint. So in any legal dispute is going to fall upon who is more believable than the other party. So these are all issues we need to be thinking about as we're developing written leases and why written leases or why oral leases may not be the way to go. If we're looking at written leases, there are some pros that go with those. We kind of look at what the cons were in the oral leases, and we start having a written record. We're allowing parties to negotiate more fully a lease that works. The thought is with a written lease, you take into account all the issues that have happened in your past leases, and you kind of make it reflect what you think will work in the future and work for the parties involved. You start clearly defining who's responsible for what. So if the landlord's supposed to take care of certain things, it becomes clearly reflected in the lease and you're not taking care of that stuff if you're the tenant. It's just a good business practice. It helps to also provide proof to your lenders that you actually have the acreage under lease that you're claiming. They may, under banking rules as they come out, not be able to take just your word for this anymore and need a written record to verify this or some sort of documentation. The cons are, if we go back to the pros with written lease or oral leases, it starts becoming some of those. You know, it may not show that same level of trust that we want in other parties. And there may be cases where you don't want a written record to exist. You may want it to be shown that you're not leasing the farmland, but someone else is actually doing it. The farmland may not be in compliance with USDA conservation compliance provisions, and you not actually having records that you rented that property may help you maintain your eligibility, which I have seen. And there may be other areas where just not having a written record would be a good thing. So I often ask this question, who is this famous person and why did I put her picture up there? And you don't have the ability to respond, so I'll let you think about it for a second, and then I'll go on to the next slide. Oh, it's not on the next slide anymore. I updated this. This is Mary Lou Henner. She has a condition called hyperthyesema, if I remember correctly. She is one of about 20 documented cases in the world. People like this remember everything that's ever happened to them on any given day and have perfect recall as to details in their lives. As I just pointed out, it only affects 20 or so people in the entire world. If you are one of those lucky people and the other party is one of those lucky people that has this total recall, you have the ability not to put together a written lease, at least with that party. For all the rest of us, we have crappy memories, and we need to think about that when we're developing these things as a way to sort of develop a lease in writing that we can at least remember what happened and develop things that are happening. The other thing we need to take into account, and I don't have a slide on this here, and I can go to the next slide, is the fact that if you look at USDA statistics, we have a large number of farmland that will be turning hands within the next, starting 2 years ago to about 2020. If this farmland's changing hands and going to new generations of owners, either through succession planning and just being handed off as a new owners or as children take over the farm, or it's passing through a will and someone else is taking over family farmland that's always been leased out to someone else, we may need that party who's taking over to understand what was developed in those leases, so they're able to take over as a landlord and figure out what mom or dad agreed upon or grandma or grandpa agreed upon, that they're then able to figure it out. Because we're looking at this and we're seeing generations changes in ownership, and that new generation may expect something different when they're taking over the property and may be thinking that you're supposed to be doing one thing that you've never had to do before. So having a written lease can help them understand, and then when it's time to renegotiate that lease, they may want to look at making changes onto it. The other reason to have it in writing is there's really no requirement, like I said before, that a lease be in writing unless the lease is for a period longer than 1 year. This is a requirement in law called the statute of frauds. All states have some version of the statute of frauds: Maryland, Delaware, Virginia, Pennsylvania. And for the most part, they cover different things, but one of the big things they always cover is a lease that is longer than 1 year needs to be in writing, but that's not always clear. I have some examples of what that might mean. So here we have a lease, my example one, it started January 1 of this year and runs to December 31st. That's pretty much a year. If you could respond with words, you could, but that's pretty much a year. There's no requirement for that to be in writing. It can be an oral lease because it's only going to last a year, and we expect it, to end and then potentially be renegotiated annually. My other example is the same lease, but it continues to run after December 31st of this year until terminated by one of the parties. For the most part, this is a standard ag lease. We see them running for 1 year and then continuing until terminated by one of the parties after the end of the lease, after the original term of the lease. This is considered a 1-year lease because in theory we could end it at the end of December 31st and never continue it. In practice, it never is. It continues on. We may have leases like this running for 20, 30, 40, 50 years, depending on how long the family has owned the land and the family that's taken it over to farm it and all the other issues that come up. So this may be a legit issue we need to focus in on as to why these leases need to be in writing. There's no requirement they be in writing, but we may actually need to make sure they're put into writing. My other example is one that clearly is longer than 1 year, started January 1 of this year, goes to December 31st. This one clearly needs to be in writing. It's longer than 1 year, so to meet the legal requirements, it would need to be in writing. So yeah, so sometimes a writing may not always be one document. It could be a series of emails or letters, depending on when the series actually happened in time. Today, we would expect it probably to be more a series of emails, potentially letters. If it was back before email was prevalent, it could also be a series of text messages between you and the other party to kind of figure out who it is. It's much safer to put it in writing at the end, just so in the end we have one document we can reflect upon. This has happened in the state to be, at least in Maryland. I'm assuming it's happened in Delaware and the other states as well. It may have not happened in an ag context in every state, but it has happened in the leasing concept for just general business leases as well. So we should pay attention to it. The other thing, to go back a slide, and I'll skip back a second, is if you do go into this situation, there are legal rules that may pull you out, where you may not have it in writing, but because you've done certain actions, you started tilling the land, you've started buying equipment or inputs to put on the land, other things you may have done may show enough to show there's a lease that we can at least imply a lease, but it may not be the lease you want. So it may in the end be putting it in writing to make it something that everyone is comfortable with. So with that, let's think about, now how do we set a fair rental rate? And this is a question that I know Shannon gets asked a lot, other county ag educators get asked a lot. What's a fair rental rate? And it's not a really easy answer to kind of give you at times, because it really does depend on your situation, and it's something you should work out to kind of figure out. But for those that are unfamiliar with how ag leases work, we have about 3 basic types. We have a crop share lease, we have a fixed cash lease, and we have a flex cash lease. A crop share lease, and the idea is you get a percentage of the crop in return, if you're the landlord, in return for renting your land. You may also cover a percentage of the input or the yield increasing inputs that go into that crop. So fertilizer, certain herbicides, pesticides, whatever we can show as agreed upon increased yield, you may end up getting to have to pay a portion of those expenses, which makes sense. It's helping you increase what you may make in the end. Fixed cash, I'm going to show some fixed cash charts here in a second for Maryland and Delaware to kind of highlight what the average rental rate is per acre per year in the state. So that's just a fixed payment every year. You would take that number, multiply it by the number of acres, and pay that annually. Flex cash is a little more in depth. The idea with a flex cash lease is I come up with a base rent that may be similar to the fixed cash rent. It may be not different. It may be discounted. It's just it's a number we agree upon. That starts out with what the rent could be. It's typically the floor rent, the least amount the landlord could get paid. Then we'll come up with what we want to flex it off of. So it may be the gross revenue from the farm. It may be the yield on the farm. It can really be anything that you want to put and kind of figure out how to provide incentive to the landlord based on this. So then you would come up with what the base yield, whatever you're flexing it off of, would be. Then at the end of harvest, we go back, we figure out what actually happened on the farm. We divide what actually happened by whatever we set as the base, whatever we're flexing off of. We multiply that number times the base rent, and that tells us how much per acre we're going to end up paying. Slightly more work than fixed cash, slightly more work than crop share. These are growing in sort of prevalence in the Midwest, mainly because everybody likes crop share leases, but because of the way inputs are being bought, it's harder to keep track of inputs that may go into one tract of farmland. It may be easier to keep it as, as for the farm as a whole. So people still like flex or crop share leases, but it's just harder to do the amount of paperwork required to keep track of everything for every landlord if you're dealing with multiple landlords. So flex cash is a way to reduce sort of that burden on the tenant to be able just to look at certain things that we can go back and peg real easy. And as you just figured out from my description of each one of these, each one's going to require a varying level of record keeping and monitoring depending on who the party is. So these are some cash rental rates that USDA NASS does a statewide average each year. They also do a county average every other year, but for some reason we can't figure out why the county average that was supposed to come out this year is actually the county average for last year. So we're trying to figure that out. And county averages don't always come out for every Maryland and Delaware county. It's all based on respondents, and if they don't get enough respondents, they can't actually release those numbers, and they may do it regionally. So some of our counties this year didn't have numbers because not enough producers responded to make it slightly harder. We're trying to run a survey here, and it got low participation rate this year. I'm working to figure out how to get higher participation rate next year to kind of make it more effective. But looking at the most recent numbers for 2017, in Delaware, we're looking at all cropland being about $109 per acre. Non-irrigated, it's about $88, and irrigated, it's about $145 per acre. Maryland, we're looking at $103 per acre. Non-irrigated. Flip non-irrigated and irrigated, that should be $190 for irrigated and $94 for non-irrigated. Sorry about that, that's on me. I apparently did not pay attention. And pasture is always fairly the cheapest. It's about $40 per acre. There was no reported pasture in Delaware averages, so I couldn't get that to you. Other things we should think about during the life of the lease is, do you want the landlord coming back on the property, or does the landlord want to come back on the property? Landlords need to think about this mainly because under the typical view, if it's not put in a lease, they don't have the right to re-enter the leased property. They have to include that right in the lease itself. So unless it's specified, they have no right to come back on the property until the lease expires. The thing to think about with that is, what if the property has recreational value for the landlord? Should they be doing something that, helps them be able to come back on the property and utilize that property in some way? And these are things you have to think about as you're developing the lease. As it says on that, they have no right to come back in if there's recreational use on the property. So if they want to go back on to hunt, to fish, to hike, to do something, they need to retain those rights. At the same time, if the landlord wants to lease those rights out to a third party, then we really need to make that clear in the lease. This is why we need to, work on written leases so we can have a little bit more ability to utilize property potentially better. The other thing they're going to have to work out is, how will this hunting take place on the property? How will it be done so it doesn't impact what the tenant is already doing on the property? If the tenant has livestock on there, do the livestock need to be moved off that property during certain times of the year while hunting is going on? So these are things we may need to think about, and it may end up needing to be other things depending on what that actual recreational value is in that property. We also need to think about, what have they agreed to contribute during the life of the lease? What's the landlord contributing? Is it just land? What's the tenant covering? Are they covering everything else? Are they going to cover part of the production expenses like we would see in a crop share arrangement? If the farm has irrigation on it and a pump breaks, who pays for the cost of that irrigation? I think that's on the next slide. No, it's not. So with irrigation, other expenses, it may end up being just through practice. It may not have to be in a lease. We may end up, with pumps and other equipment, depending on where it's located on the property and in the irrigation system. It may actually fall on the landlord to fix just based on practice. Other things may fall on the tenant with irrigation to fix. So typically, it's I believe if I remember correctly, it's everything from the pump down to the aquifer that the landlord takes care of, and the tenant takes care of everything else. What about general liability insurance? The tenant will typically need to make sure that their equipment on the property is insured, but if there's buildings, other permanent structures, other things that are happening on the property, the landlord may want to take out some type of general liability insurance. If the landlord's taking on recreational uses on the property, they may want to make sure that they have that covered, and in some way the tenant may want to make sure that they're covered under that policy in case somebody gets hurt on the property while they're involved in the recreational use and then decide to sue the landlord. Crop insurance, tenant typically has a burden to pay for crop insurance if it's crop share or flex cash and cash rent. If the landlord is involved in a crop share process, then they typically would split crop insurance proceeds and the costs of those as well. Typically in flex cash and cash rent, the landlord has no risk of loss, so they actually can't take any crop insurance out. And they only have risk of loss when it comes to a crop share rental agreement. Oh yeah, slide's in the wrong spot for some reason. Traditionally, we look at this, the landlord will typically cover everything below the ground plus any major expenses with the well, up to $500. Landlord would also supply a center pivot system if that's the type of irrigation, mainly because that potentially would be the one that's supposed to stay there if you give up the property. Tenant typically furnishes fuel, power plant, and any minor expenses. So my earlier comment on the pump, please forget, it typically would potentially fall on the tenant. Good husbandry practices. So we talked earlier, there is a book on our website related to kind of conservation issues, but typically within almost all these leases, we need to think about the fact that even if it's not addressed, it's potentially just implied in all ag leases that you're going to use some form of good husbandry practices in this. And this typically means that we want to conserve fertility, usefulness, and value of the soil. If we think about the property as an asset for the landlord, conserving fertility, usefulness, and that value of that soil, that's maintaining their investment in the property. And if we allow tenants just to come in, do whatever they wanted to do to the property, misuse it, mismanage it in some way that it reduces all this, there would be huge value loss to the owner of the property, and they may potentially not be able to reclaim that. So in a lot of these cases, we just imply this is existing in most ag leases. I say that it's never been actually proven in Maryland this exists, but it has been implied in Delaware. But it seems like something that if we took it to court, it seems easy to get a court to view this as something potentially that should exist. So it seems like something we should just address early on in the lease so we understand what we're actually meaning. So then we don't have a court kind of figuring out what this duty actually means to us, that we should just address it early on in the lease. Other things to think about are we really need to set a rental payment date. When do you traditionally pay this rent? Things you should think about. Then think about 5, 10, 15, however many years down the future you're willing to think. And, you know, if we're looking at an issue where we could have succession and a new owner take over, or someone's going to buy the property and take it over, does that owner have enough background in ag to understand what tradition is? The owner you're dealing with may be somebody that was raised on the farm, understands just based off what mom or dad did. And now, in a situation where their kids are taking over, they've only visited, you know, periodically when they went to visit grandma and grandpa as a kid. Now they may not understand what tradition means on this just because they haven't been exposed to it. So maybe we need to just write that into the lease to kind of take care of problems. And that will help us with other issues so then we know when rent's potentially late. Yeah. So having it set out clearly, then how many days is considered late, potentially what happens when it's considered late is an issue we want to address in a written lease. We need to look at these written leases as documents that we can use to sort of answer not all the questions, but lay out a framework so it's fairly clear as to what we intended to do. And we don't have to write a very long document to do that. It can be very short and concise, but we need to think about, you know, what we want to address in these documents. The other thing to think about when we're setting this rental rate payment date is to think about with crop share and flex cash leases, you really do need to set it past that harvest date to give you enough time to get records in order, to recover from harvest, to get ready to where you want to go in. And so it may be, you know, first of the year we want to go in and do this, or it may be later in the, you know, sometime later in the year we want to do it. But we need to think about what's going to work based on the way our production cycle usually operates. The other thing to think about is what happens if rent isn't paid. In Maryland, Delaware, if I remember correctly, you get no statutory lien in, automatic statutory lien in growing crops for unpaid rent. You could add language into the lease to kind of create the security interest to get that. That is not in the form leases because you need to make sure you're working with an attorney to make sure all the steps are met to get that. With crop share leases, a statutory lien does exist automatically, and if we think about that, that makes sense because, you know, if you're growing or renting on a crop share basis as a landlord, you actually have an interest in a portion of that crop, so you should be able to have a lien in it. What about lease termination? And this is where issues have often popped up. Your lease may just terminate on a certain date. If we go back to my examples, if it comes to the end of the year, it says it runs for 1 year, there's no language to continue it on, that lease may end at the end of this 1 year. And you may not have to give notice. It may be a good idea to give notice, but you don't have to really do anything to end the lease. Now, if you do put in a termination process, you do need to follow that termination process, whatever it is. My typical example is, if it says, you know, 4 months prior to termination, you need to provide notice via a carrier pigeon, you better find a carrier pigeon to deliver your notice of termination. If it's got to be mailed, you need to make sure it's got to be mailed. If you've got to email it, make sure you email it. The reason for that is courts are more likely to force you to follow your own process that you agreed upon than they are the process that's in the statute if you don't have one. The statutory process they will be forgiving on. The one you agreed upon, they are not forgiving on, and they like to see those followed exactly. Why you agreed upon it, you should be able to follow it. If it doesn't have one, I have this also for Delaware as well. The lease doesn't have one, then you follow what Maryland law says. If you're in Maryland, it requires 6 months notice to terminate the lease. That lease termination should be in writing. One thing in the sample book, or the leasing book, is a sample notice of termination and how you can send that. It doesn't have to be sent certified mail or anything. Delaware, if the lease doesn't have one, then you follow Delaware law, and that requires 4 months notice to terminate a lease. You should also pay attention to when that is required. Delaware does have it spelled out specifically on some of the dates. I believe it's 4 months before January 1. Maryland, if you don't know the exact date, you should just assume to give it by June 30th. And that would be about 6 months till the first of the year. What happens if we have growing crops at termination? You know, this is an issue that pops up. The common law view was if we had a definite termination date, then you weren't entitled to growing crops. Going back to the earlier examples, example 1 that ran for 1 year, January 1 to December 31st, that's a lease with a definite termination date. If you were to go in and say plant something to be harvested later in the next year, you knew the date, you shouldn't have planted it, you've got to follow the process, you don't get the crop. That said, there are exceptions to this rule. I should go back and say, if you're in one of those leases that says for 1 year and then continuing on until terminated by one of the parties, that is an indefinite period, and that's something else we'll talk about here in a minute. One exception is the doctrine enablements that we'll talk about in a second. I guess we talk about it now. The doctrine of enablements is an equitable doctrine designed to protect farmland lessees / tenants. The idea is the former tenant has the right to re-enter and cultivate, harvest, and remove crops that were planted prior to the termination of the tenancy. So once we know the tenancy is terminating, you can't plant anything and expect a right to harvest it. If you did it beforehand and it just comes out of the blue, then, you know, it happens. When does this doctrine apply? The uncertain duration, we go back to that lease where it continues on until terminated. That's an uncertain duration because we don't know when it's going to terminate unless it's in that first year. The termination has to be due to an act of God or an act by the landlord. If you forget to pay your rent on time or do something that, you know, puts you in breach of the lease, that's not through an act of God or an act of the landlord. That's on your own act, and that's your own fault, and this doctrine doesn't apply. It has to be planted during your right to occupy the tenancy. If it's planted after the termination is given, then it's not really planted during the right to occupancy. Typically, it only applies to annual crops. So corn, soybeans, watermelons, wheat, stuff like that. A few states, Pennsylvania is one of these. Maryland and Delaware, from what I remember, have no reported cases going down into perennial crops. So looking at grasses, hays, forage type crops that would be grown, used over a period of time. Probably certain trees and other crops. This doctrine doesn't apply to them. The idea is, you know, every lease is going to have some termination date, and you should not be able to maintain a lease and hold it open just because you decided to plant a crop that could potentially be harvested over and over and over and over again. If we go out and this doctrine doesn't apply to you, we need to look at, you know, what's practice in the area. If practices and common, you know, things that have happened traditionally, you would have the right to come back in and harvest the crop. You may have that right. The simpler thing to do in all of this is just write in the lease that, you know, if crops are growing at the end of the lease, you have a reasonable time to come back on the property and harvest that crop. Some of these doctrines, you may think this is great. There's this doctrine that will save me. But at the same time, it's just easier with a lot of these doctrines to write it in the lease, handle the issue early on, and then there's no guessing that you have to make sure that any of these doctrines apply to you. It's just spelled out in the lease, and it's already taken care of to save you some of those issues. And are there any questions? I should have left a good amount of time for questions.
Well, we had a couple questions that came in through, and then as the participants are thinking about your presentation, they can type them in the chat pod. But we did have a question about the rental agreement if the landowner passes away. How does that impact a lease or rental situation?
So if somebody passes away,
Yes.
okay, it won't impact it in any way. Really, the estate will take over. So at that point, you would be paying rent. You'd have to make sure you make rental payments to the estate. Then potentially, whoever inherits that property or gets that property through the will would then take over. And potentially that next party could decide to cancel the lease, but initially nothing really will happen. It just changes who you pay for a while, and then eventually things could happen.
And they would have to go through the termination procedures like anything else. Is that right?
Yes. Yep. They would have to follow the termination process in the lease. So if we look at it, whoever owned the property that you did the lease with originally, we would just substitute out the heirs for that person. They would become the landlord, and then the new landlord could eventually decide what to do with the property.
Okay.
What other great questions do we have?
Yep, we've got another one. Does good husbandry imply no-till agriculture?
No, it doesn't imply it. It would mean anything from no-till to conservation tillage to somewhere, as long as we're doing it in a way that doesn't promote soil erosion and still promotes conservation, traditional conservation practices.
So if somebody wanted no-till agriculture done, that should be explicitly said?
Yes, that should be explicitly said. I mean, the example I would use is, I know it's not here because not many people still till, but where I'm from in Oklahoma, you know, good husbandry practices would be you could still till, but you would need to maintain terracing and other conservation practices that are designed to prevent soil erosion and promote fertility. So.
Great. Other questions for Paul? You have an ag lawyer at your question service.
It's really good to know on my PowerPoint, my webinar yesterday, nobody responded to tell me that they were seeing the speaker's view and not the slideshow.
Yeah, it's odd.
Like, I asked 4 times and nobody ever responded and said, hey, Paul, we're not seeing the right thing. Awesome.
All right, well, the leasing guide covers, I think, a lot that's in there and the samples. So this recording will be posted hopefully by this afternoon, if not tomorrow, and sent out to everyone that has registered. And then on the page also will be the slide set. And so you can download those as you like.
Cool.
All right, other questions?
Thank you.
Well, thank you, everyone, for tuning in today. We have 2 webinars that will wrap out 2018, so hope to see you there.
Thank you. Thank you. Have a good day.
You too.
I could stop sharing.